far away was the nearest crosswalk?
The nearest marked crosswalk,
Nearest marked
I don't believe the record has any indication of where the nearest marked crosswalk was. There's just simply nowhere nearby. There is a, under the applicable code, I believe it's the vehicle code, there is an implied crosswalk at every street corner, whether or not it is painted on the street. They knew for years before this incident happened that when people parked at the pool parking lot, they were very likely to then cross directly from that pool parking lot to the church, which was directly on the side of Marconi, instead of walking down to the corner of Route and crossing.
Well, by the same token,
over.
I assume that members of the church had traveled Marconi Avenue at different times of day and night in different weather for different holidays, and so it wasn't a surprise that it's a 5-lane thoroughfare with cars moving at a pretty high rate of speed.
Well, it was a surprise to Mr. Vasilenko, who had never been to this property before.
And then he chose to cross it at midnight, in the dark, and a rainy evening.
Well, he was going to cross Marconi either mid-block or at the corner either way, and they're the ones who put him in that position of having to cross Marconi when he did not have to do that.
They, meaning the church, put
Correct.
Mr. Vasilenko in that busy thoroughfare? He had
Yes.
no part of this himself?
He had a part, I believe. If you look at the Bonanno case, for example, there's comparative fault assigned to pedestrians, to motorists, to the transit authority. It's not that 100% liability is going to be placed on the church. There's going to be comparative fault assigned to the driver, probably a very substantial amount to this driver who is driving above the speed limit in the dark, in the rain, while trying to deliver a pizza quickly. So there's going to be probably a majority of fault assigned to the driver. There may be some fault assigned to the church and some fault assigned to Mr. Vasilenko. I don't think there's any injustice in that, no unfairness to anyone, and I think it allocates the fault in a way that a jury
If we
allocates.
find the first matter of law question of duty.
Correct. I wanted to address the argument that was raised about premises liability. Defendant is relying on the premises liability defense basically on the theory that's been stated in other cases as, to find a duty here would take the premises out of premises liability. But in Kessner, this court rejected that truism. It recognized that premises liability is just another species of negligence. And you're going to apply the same negligence standards in whether it's called a negligence case or premises liability case. Rowland v. Christian itself was a premises liability case. So there's attempting to recharacterize it as a premises liability issue versus a negligence issue is not going to avail the defendants at all. And in fact, the plaintiffs have never framed this as a premises liability issue. Both the third and the fourth causes of action are framed as general negligence causes of action. So there's nothing to be gained for the defense there. This case is similar to Anaki. It's similar to Barnes. It's similar to Swanberg versus Omecton. Various other cases when it's viewed as a situation where the plaintiff was not on the defendant's land at the moment of the plaintiff's injury, but the defendant, through conduct or some condition on the defendant's land, created or increased the risk to someone not on their premises. And that is not a novel concept. This case is also similar to Bonanno and also similar to the explanation given in Alcarez about a Court of Appeal decision, Hamilton versus Gage Bowl. The Court of Appeal in Hamilton versus Gage Bowl said that a defendant bowling alley owed no duty to the bowling alley's invitee who was in the bowling alley's parking lot at the time that a sign detached from a building adjacent to the parking lot and landed on the plaintiff there. because that defendant had no notice that that sign was at any risk of detaching and falling, and had no power to go onto the other property and inspect the sign to check whether it was faulty or not. Alker has explained, however, in that case, if the bowling alley did have notice that that sign was at risk of detaching and falling, then the bowling alley would have been liable for that. So that is precisely the same situation as existed in the Bonanno case. Bonanno considered the plaintiff there to be a user of defendant's land, even though that plaintiff was not on defendant's land at that time. The court found that she was no less a user of that land because she was attempting to access that land at the time of her injury. And they used the analogy of, well, what if the defendant required the defendant to jump over a ditch in order to reach its land? If the plaintiff had fallen and injured herself in the ditch, then the defendant would be just as liable as if the plaintiff had fallen while on defendant's property. So the principle is that the defendant had actual notice that a danger on adjacent land exposed persons using or attempting to use defendant's land to a risk of harm. So I don't see that recognizing the duty in this case is in any way an extension of pre-existing law. It's merely an application of pre-existing law to a different set of facts. Another point I'd like to make is the distinctions between this case and cases like Sieber and Steinmetz and Navarez are that in all those other cases, the only connection between the defendant and the injury that was suffered to the plaintiff was that this hazard happened to be near the defendant's land. The defendant did nothing to increase the risk. The defendant did nothing to cause that person to encounter the hazard. This is in contrast to cases where defendant's negligent management of its property did increase a pre-existing risk of harm from street traffic. And that would be Bonanno, Anaki, Barnes. And the idea that well, there should be no duty because you're on your own if you're a pedestrian doesn't fly when you look at Bonanno. Bonanno didn't say, well, tough luck, plaintiff, you were required to cross a dangerous street, but you should have been a little bit more careful before crossing. If you look at Anaki, the person in Anaki who was the plaintiff was at the decedent in that case was a passerby, wasn't even an invitee of the restaurant. The restaurant set up its parking lot in such a way that its patrons were likely to leave that parking lot in a way that created a danger to people who were on the Pacific Coast Highway. They didn't advise the person that they couldn't turn left. So the person attempts to turn left. He said you could only turn right. And as a result of that, this motorcyclist who's passing by collides. And the court found not only that was there a duty owed to the invitee to give the invitee proper warnings when it had knowledge of this danger, but also owed a duty to this mere passerby. And there were thousands of passersby every day on the Pacific Coast Highway. And if that restaurant created a risk in the way it managed its parking lot, then it owed a duty to all those thousands of invitees. That is a far greater scope of duty than restricting the duty as we have offered to invitees only of the defendant, where the defendant establishes a lot in a place where it knows it's going to be dangerous to have ingress and egress and requires people to use it. There's no burden. I don't think there's any consequence to society other than a beneficial consequence to society. I'll conclude, and I see I'm almost out of time, but if you take a step back and say, well, what is this case really about? It's an interesting law review examination, but there was a series of very, very bad decisions that were made by the defendant in this case. I would submit that those decisions were indefensible based on what the church knew about the danger it was putting people in, and that there was no social utility to what the church did, and that this is not the sort of activity for which the church is entitled to a categorical immunity. I'll conclude unless there are any further questions.
Thank you, Mr. Tarana.
Thank you.
I think the questions by the court makes it clear that the church had no control over Mr. Vasilenko when he chose to cross the street in the manner that he did. He's not an automaton. He's given a map with various areas that he can park his car. This is a situation where he can no longer park at the location of the church's general parking lot. And I believe Justice Chin, your question about the pastor's lot, I don't believe that lot was available. The issue is, where is he going to park now that the parking lot's no longer available?
That lot would actually make it more dangerous because he would have to cross two streets.
That's right, and I think that the issue we have here is one of, we look at the facts in a more generalized sense under Cabral, because the issue is there a duty of care in making somebody cross a public street? And he's not being made to cross a public street, it's just a public street is there. Crossing a busy public street is not an unreasonable risk of harm. It just cannot be conditioned that way. In all the cases in Anoki and in Barnes, the courts find that it is a condition of the premises. And in Anoki, the court makes it clear that the driveway leading out of the parking lot is confusing to drivers, and they might turn left and cause a motorcycle accident or some other condition. In Barnes versus Black, it's very clear you have a steep driveway that ejects a child out into a busy street. None of those conditions occur in the church's parking lot. Bonanno, the court found the location of the bus stop a dangerous condition of government property under the government code, of public property under the government code. There's no finding, there's nothing wrong with the adjacent parking lot that the church uses that ejects people out into the street or caused this accident.
I think the claim on the other side isn't about the nature of the property and, any misdirection given at the property. It's about the siting decision, where to locate the lot. And I pressed counsel on the notion that, I think we can all agree the church has no obligation to actually have a lot, but we could say that if it is going to have a lot, it should choose the best one.
Well,
doesn't that seem like a decent rule of thumb?
Well, no, Justice Liu, I don't think so, because that's not in our modern society in the way premises or business owners make or have available to them off-site parking. They may have more than one lot available, and to put a burden on premises holders to decide which lot is relatively safer than another, say in downtown San Francisco or anywhere, which lot is more safe than another, we have to cross Market Street. We have to cross other streets. This is not an unreasonable risk of harm.
Mr. Laurier, your time's expired.
Thank you.
All counsel, thank you. The matter is submitted. Calling the matter of the People versus Christopher Henriquez, and sitting on assignment, we welcome the Honorable Herbert I. Levy, Associate Justice, Court of Appeal, 5th Appellate District, assigned. And when you're ready, counsel, you may begin.
Good morning. My name is Oscar Barbaro. I'm here to, with the court's permission, argue the denial of a fair cross-section in the jury veneer. Mr. Kaufman, my co-counsel, will address Argument 8 regarding vengeance and any other issues and answer the court's questions in all other areas. I do wish to reserve 5 minutes of time for my rebuttal. If there has been a chronic and significant underrepresentation of a protected class of potential jurors for decades, the jury commissioner must take remedial measures in an attempt to correct the disparity unless there are compelling reasons for maintaining the status quo. But here, the only actions taken by the Contra Costa County Jury Commissioner exacerbated the problem. In the trial court, the government and the trial court did not dispute that for over a 20-year period, leading up to and including the summon veneer in this case, Contra Costa County engaged in a system of jury selection that consistently underrepresented a significant portion of the African-American residents in the jury system. So at the time of petitioner's trial, it became clear that the underrepresentation of African-Americans in the jury veneers in Contra Costa County had become inherent in the process of jury summoning. This is acknowledged in the trial court record, and it is extensively documented and acknowledged in a multitude of Contra Costa trial and appellate court cases, and in the decisions that preceded this case. The jury commissioner has been a party to all of those case decisions detailing this phenomenon, and this court acknowledged the disparity in 1989 in People versus Bell, and the Bell record was established in 1979. It is the government through the jury commissioner that is solely responsible for the operation of the jury system, and thus it is their obligation, required under the Constitution and by statute, to develop a system in a manner that produces a fair cross-section of the community served by the court. The language of the prosecutor who opposed and litigated the motion to quash the petitioner's case and litigated the case in People versus Curry for months before this case stated, "No one is defending the historic underrepresentation. Even under the best scenario today, there is an underrepresentation of African Americans under the best view of the jury commissioners and the people's evidence."
So our cases are, as well as the United States Supreme Court's cases in this area, are clear that to make out a violation requires more than just underrepresentation. It also requires traceability of that underrepresentation to an improper feature of the jury selection process. What, in your view, are the improper features of the process at issue here?
They're fivefold. The jury commissioner made the decision to hold only misdemeanor trials in the courthouse located in the city of Richmond. In the face of the evidentiary record we presented in this case, which was not presented in the Curry case, but was presented in Mr. Enriquez's case, we established that the African-American population of the area of that county was in fact appearing for jury service consistent with their numbers in the population. The African-American population in the West County area, the area served by the courthouse in the city of Richmond, was approximately 23%. The African-American population that showed up for jury service in that location was 26%. That's the evidentiary record. The decision by the jury commissioner was, we are not going to hold felony trials in that location. We're going to hold them 20 miles away in the city of Martinez, despite the evidence that we presented.
So my understanding on that point is that the trial court looked at that argument and said that actually the statistics don't bear out that the location of the courthouse has a meaningful effect on the rate of African-American jurors showing up for jury selection, and that it's really other factors, principally failure to appear, that seem to be causing the disparity.
I think that the trial court's comments about the failure to appear ignored the actual evidence that we presented on who is appearing and who isn't appearing. And the trial court, in reviewing those comments, seemed to equate the failure to appear numbers in the Bay Judicial District, where the Richmond Court is, and the failure to appear numbers with the Martinez Courthouse as being the same, and therefore it basically is a wash. It's not a reason to find a inherent feature is problematic with the jury selection process, or the jury summoning process. But that ignores the feature that I just talked about, is that the jury commissioner and the representative for the jury commissioner, I was going over the actual trial court record yesterday, and the county council made a statement that the jury commissioner doesn't know who is not showing up. They don't do any kind of follow-up to determine whether or not the failure to appear rate in the Martinez Courthouse is in fact an African-American population, or the failure to appear rate is an African-American population in Richmond Courthouse. They don't do any of that determination. And so the point I'm making is that the Richmond Courthouse evidence is that there is not a failure to appear of African-Americans in that location in proportion to their numbers in the population. And the decision by the jury commissioner to only conduct misdemeanor trials in that location ignores that evidence and further entrenches the system of underrepresentation in the courthouse in Martinez.
There's reason to believe that the failure to appear rates might be different between African-American residents of the Bay District and other residents?
Well, we put on extensive testimony about the inability to travel, and that is one of the issues, one of the other issues, the inability to have public transportation from the location of African Americans in the largest concentration of where they live in the county, in the Bay Judicial District, that is serviced by the Richmond Courthouse. It's 20 miles to the city of Martinez. It's also 20 miles from the other pocket of the largest segment of the African American population. And to only hold felony trials in that location without public transportation from those two locations further entrenches the inability of the African American population to arrive at the courthouse where the felony trials are being conducted. And again, it has to be juxtaposed with the evidence that we presented in regard to who is showing up in the courthouse closest to the population centers where the African American population resides. And so that second decision by the jury commissioner to hold only felony trials in the city of Martinez 20 miles away from those locations further exacerbated the situation. And the hardship excuse policy that's on the printed jury form that's in the record here says that if it takes you more than an hour and a half to get to the court from your location, you are excused from jury service. And we put on testimony in the Curry record, which was part of the Enriquez record, that it takes almost 2 hours from a number of locations in the Bay Judicial District to get to the courthouse in Martinez. And so there's a hardship built into the way that this is being conducted, and yet the jury commissioner continues to operate in that fashion. The other decision that the jury commissioner makes is to hold misdemeanor trials in the courthouse in Walnut Creek, which is in the south section of the county, for misdemeanor cases that come from the largest and most populous section of the city in the county, which is Concord. They move those cases, those misdemeanor cases, out of the city of Martinez and not held in the courthouse in Martinez in order to make room for, again, only felony trials to be held in that central location 20 miles away from the largest segments of those populations. So that's their third decision. And the fourth one is the arbitrary decision to divide the county into 4 different judicial districts and to summon an approximation of the % of the population in each. But when actually summoning they are summoning less jurors from the districts with the higher concentration of African Americans and more from the districts with the lower concentration of African American residents. That's evidenced by their summon yield report. They get a report that says, this is how we're summoning. We made the decision in order to do it this way. We're going to divide the county up into 4 different districts and summon according to the numbers that we believe are in each district. And then based on the report we get about that summoning process, it shows us that we have an underrepresentation of residents from the areas where the highest concentration of African Americans live. And knowing that, what do? They summon again the next year in the exact same fashion. They're entrenching this system by decisions that they're making in order to perpetuate it rather than correct it. Finally,
So is one of the remedies that could have been employed to summon a larger proportion of African-American potential jurors to counteract the failure to appear rate?
I believe so. I believe that the county could engage in whatever remedial measures it saw fit in order to better reflect the African American population of the county.
If we begin with the premise that being summoned to jury duty, compelled by the government to show up someplace and be away from your family and your work and all of that is a burden, then, and I think we can all say that, because probably most of us have been summoned to jury duty, wouldn't a counter-argument then be made that the African-American population is being imposed upon unfairly because they are being overly summoned to be away from work, et cetera, et cetera?
I don't know who would raise that objection in light of the fact that, as this court obviously knows, the criminal justice system prosecutes minority populations in gross disparity to the way it prosecutes Caucasian citizens. And to say that the African American community would be taken aback or pose an objection to being more involved.
I'm not suggesting that people might or might not be in favor of such an alternative. I'm simply observing that if you say we're going to subpoena people based on their race, recognizing that it's a burden, that is something that at least should be considered in the mix, or do you disagree?
I don't know that it would be considered a burden. I think what it would be doing is saying, look, the way we're summoning now is not getting us the equal numbers of the population that we should be getting in the summoning process. We're summoning 4 different districts. We're getting less than the district population that has the largest segments of the African American population in that pool by doing it this way. And so the suggestion of should we over-summon from the areas in which those populations and those people live, yes, we should, because that way we would get an equal number, at least, or a greater number of the populations that come from that county. But doing it the way they're...
I get it. So at the outset, you said that there were 5 actions by the government that
Yes.
result in this disparity, and
Yes.
we've heard about 2 of them.
I've
And I want
actually-
to make sure you get a chance to fill out the other 3.
Sure. There were, I thought I had been through 4. The first was to hold all the felony trials just in Martinez. Sorry, the first was to
Misdemeanor
hold only
trials
the
only in
misdemeanor
Richmond.
trials in Richmond. The second was to hold only the felony trials in Martinez. The third was to move out the misdemeanor trials that occur in the largest city in the county to the Walnut Creek District in order to make sure that the felony trials can be held only in Martinez. The fourth was to divide into those 4 judicial districts and summon in that fashion in light of the numbers that are produced by the summons yield report. And the fifth is the continued decision to only summon jurors using voter registration and the Department of Motor Vehicles lists. And I know that those lists, and there's been a great number of cases that deal with those lists being deemed race neutral. But we put on expert testimony that those lists do not give you a race neutral group of jurors when they're being summoned. And the Code of Civil Procedure allows for additional lists to be used. And the jury commissioner, in the face of that expert testimony and that underrepresentation, and in the face of the report from the California Judicial Council, which examined racial and genetic bias in the court, and recommended, that the courts be cognizant that minority residents are more likely to vote in lower numbers and disproportionately live in poverty and have less economic means than other citizens of the county, that despite that information and the fact that the court took judicial notice of that report and the fact that our expert testified that using those two lists underrepresents African-American citizens in the jury pool, the jury commissioner has chosen again to only use those two lists. So there are 5 strategic operational decisions that are being made by the jury commissioner that are choices, basically, in order to entrench this system of underrepresentation that's been documented by this court and several other courts before it, and to continue with this system despite the clear denial of a fair cross-section. So to say that this is just as the people do, to say that this is just a complaint based on the fact that there is a statistical underrepresentation is not an accurate representation of the record. The record is that the jury commissioner has been made aware of this underrepresentation and has done nothing to correct it. The Duran case, upon which all of this litigation stems from, said that statistical evidence that simply tends to show a causal relationship between the underrepresentation complained of in order to establish a prima facie case of systematic representation can be enough. And in Duran, there was only a year of underrepresentation that was presented. Here we have an admission and Court of Appeal cases of 20 years. And so really, I stand here before this court and ask, at what point does this county's system of jury selection, which is documented to underrepresent the African-American population, at what point does it become a constitutional violation, a systematic violation of the right to a fair cross-section? I think the point is now. I think the point is this case. I think the point has been established in this case by the record that we presented, by the evidence that we presented, and by the failure of the jury commissioner to do anything at all to correct it. This court has stated that inclusivity in jury service promotes citizen participation in government, legitimizes judgments of courts, and prevents further stigmatization of racial minority groups in our society. To say that 20-plus years of underrepresentation doesn't even rise to the level of a prima facie case of systematic exclusion, especially in light of the jury commissioner's intentional actions that I just outlined, that were taken to ensure the continued operation of the current system in the same manner, and no action or effort to remedy the situation, seems simply absurd. By finding petitioner was denied a fair cross-section here, we're simply asking this court to right an identified wrong that no one reasonably disputes exists.
Mr. Barbara, you'll have 2 minutes for rebuttal.
Thank you.
Good morning. May it please the court, Scott Kaufman from the California Appellate Project. I would like to briefly address Argument 8, Subsection D, related to the vengeance question that was raised in the AOB. In this case, the district attorney explicitly argued that the victim's family is entitled to vengeance, plain and simple. And this was in the context of an extensive presentation of victim impact evidence, which included other people who weren't even members of the families of the victims. It was an extraordinarily emotionally charged case. And it was a very, very difficult case. And to add this layer of vengeance to it, I think, crossed the Eighth Amendment line. And this is an opportunity for this court to finally rein in a little bit of what is going on in the trial courts in relation to the presentation of victim impact evidence.
Does our decision in People versus Sanchez last year help us resolve the claim of prosecutorial misconduct in this case?
I don't think Sanchez was as close a situation as in this case. I think this case is a clear presentation of an argument by the district attorney relying on the issue of vengeance for particular victims of the case. This is not a situation like in Zambrano, for example, where there was a discussion about the right of the community to extract vengeance, the right of the community as an abstraction, as in a general way. In this case, he was specifically referring to the victims themselves and suggesting that they deserved vengeance that could only be imposed through the community action. The problem is, in the context of, go ahead, I'm sorry.
Agree with you, is it harmless error?
I'm sorry?
If we agree with you, is it harmless error?
Well, I say no, it's not harmless error. I would like to start off by saying I think it's structural in this case because I think it's difficult to truly assess it. But I would say this. This case has a multiple number of issues related to instructions that were given and statements that were made to this jury about weighing, whether there's the weighing process and what the weighing process is involved. There was extensive discussion regarding whether there would be, whether there was equality between mitigation and aggravation, whether if you had no evidence of mitigation, would that be sufficient for a jury to find life, even in the absence of mitigation? And tied to that as well was an argument related to the absence of, or actually the prevention of the defense attorney from arguing for mercy, which is also, there was an assumption that mercy was somehow covered under the ideas of compassion and pity and sympathy. And I suggest to you that's not the case. When the district attorney is allowed to argue vengeance on the one hand and the defendant is not allowed to argue for mercy on the other, that's an unfairness. And the prejudice flows from that unfairness because it's not a fair distribution.
Counsel, is it your position that the use of the word vengeance, even if it's isolated by the prosecutor, is not only error, but it's structural error, even if it's just one mention?
I'm saying that this has to be taken in context. It has to be taken in the whole. You can't look at it in isolation and just say, well, it's a small statement. He only made that statement once. And I should point out, by the way, there was an objection made, which also distinguishes this from Zambrano. There was no admonition given to the jury. There was no instruction given to the jury not to consider vengeance. And
Was there a request for one?
I'm sorry?
Was there a request for one?
There was not.
So there was an objection made. The objection was sustained. The prosecution was admonished to honor
She was
the
told
ruling.
to comport yourself accordingly. That was what she was told. And then she immediately said thereafter, the death penalty is here so that victims, in a sense, have a voice. What is justice in this case? So again, she's pointing back to the victims and their desires and rights for vengeance. She's implying that she has some sort of
Well, the dead
knowledge.
victims are entitled to a certain degree of justice as well, are they not?
I'm sorry.
The deceased victims are entitled to a measure of justice as well, are they not?
Certainly, the deceased is entitled for the entire community is entitled to justice.
So
but the question is whether they're
prosecutor's
entitled to
reference to victims is somewhat more inclusive than the surviving family members. Isn't that right?
It's the focus on the victims individually, which is what happened in this case, is what distinguishes this from Zambrano, I think. And to that extent, I think that's where it crosses the line. And what I'm suggesting to you is that this is an opportunity for the court to put some limitations on what kind of arguments the district attorneys are allowed to take. What happened here is that this district attorney is obviously a very good lawyer. She has been following the case law. She has seen the development of the case law, and she realizes that she might be able to make this argument and stretch it a little bit further. And that's exactly what she did. And she got called on it. There was no admonition. But the fact is that in the context of the entire argument, it was inflammatory. And it really did step over the line of the Eighth Amendment. Now, as to whether or not it's harmless error, I submit to you it's not harmless. But in any event, I still think whether you find this is prejudicial to the case or not, I think it's important for this court to set some real limits on what district attorneys are allowed to say in the context of victim impact.
Can I ask a clarification? I think I understand your point, and that is that you admit that the prosecutor did not request vengeance on behalf of the victim's family, did not expressly say that, and in fact sort of disclaimed it and said that the victims are not entitled to personal vengeance. But then goes on to say, and that's all proper, but then goes on to say, in return, they, the victim's family, are entitled to vengeance, plain and simple, from the state, because they're not allowed to get it themselves. Is that statement improper? Just expressly not out of context, but in isolation?
I think it's improper. I think it's a violation of the Eighth Amendment as a...
Is it a violation of Zambrano and or Sanchez, as we have said in the past when we've talked about request for community vengeance is not improper?
I think it is in this case, because I think it's in the context of the other victims. There's specific victims.
So expressly that phrase is not a violation, but you're saying in terms of the entire argument that the DA made about the victims here,
Yes.
It is?
Yes, that's exactly right. That's right. Anyway, if you have any other questions, I will submit it.
Thank you, Mr. Kaufman.
Any other questions at all? Okay, thank you.
May it please the court, Ronnie Pomerantz on behalf of the state. I'll first start with the fair cross-section arguments that have been made here today. I want to address first appellant's assumption that there is significant and chronic underrepresentation of African Americans on Contra Costa County jury veneers, and that this was somehow assumed to be true below, or that this was somehow conceded below. I don't think that's the case. I would start first with the fact that the prosecutor heavily litigated this issue below, and specifically said below that he did not agree with the numbers that were found in Curry, and that he wished to build on the record in Curry. But I would also point this court to the fact that since 1982, I believe, which is our first published opinion on Contra Costa County jury veneers in People v. Buford, the California Court of Appeal decision, since that case, we have not had a decision that has addressed Contra Costa County jury veneers, which has actually found a constitutionally significant underrepresentation of African Americans on Contra Costa County jury veneers. And to the contrary, there's actually been a downward trend in the underrepresentation that these decisions have shown us. For example, in Buford in 1982, I believe the highest number, the absolute disparity there was up to 7.2%. Subsequently, in 1984 and 1985, there were decisions, Court of Appeal decisions, that talked about the number being in the mid 4% area. Finally, or later in Bell, this court found that a 5% absolute disparity was insufficient and was not a constitutionally significant disparity. And then finally, in Curry in 2001, the California Court of Appeal, in addressing this precise issue, declined to decide the issue, but noted there that there was a 3.8% absolute disparity, and that did not rise to the level of the 5% absolute disparity that was present in Bell. And so I just wanted to first point out that to the extent appellant is making this assumption and holds that all the parties below made this assumption, or that this court should make that assumption, I don't believe that the case law bears that out. And I would just conclude that point by pointing out that here the absolute disparity is 3.5%. So it's by far the lowest underrepresentation that we've seen in any case discussing Contra Costa County. Moving on to some of appellant's other points on the fair cross-section issue, I just want to point out that appellant speculates that there are remedies that Contra Costa County can undertake to address the underrepresentation, but even putting aside the fact that a county's failure to undertake a remedy, even putting aside the fact that that is not legally material to this court's decision under Duren or under the fair cross-section analysis, the trial court below did engage in these proposed remedies and did consider the speculation that certain remedies might work. And the trial court did present statistics, which were actually not disputed below, about how some of the speculative remedies would work, and found there was no basis to find that Contra Costa County, found there was no basis to find that the defendant's proposed remedies would actually increase the percentage of African Americans on the jury veneers. And that were things that included the transportation issues or the geography issues that the appellant has posed here.
What about the use of voter lists that are derived entirely from motor vehicle records and voting records?
There was speculation below that the county could be doing more to supplement those lists. I believe the trial court actually invited argument on this point and said it's not clear, it wasn't clear to the trial court what additional lists Contra Costa County should be using. And of course it is conceded, I believe here too by appellant's counsel, that the DMV and voter registration lists are race neutral and are acceptable under California state law. So I do think, again, Your Honor, the trial court here did sort of engage in the speculation and invited counsel to suggest additional lists, but that there was no satisfactory suggestion that was made below. And as this court is aware, I would also point the court to the fact that there have been several cases that this court has decided in which defendants have claimed that counties should supplement the source list. And that, again, the failure to supplement race-neutral source lists can't be in itself a violation of the Sixth Amendment or in itself a prima facie case of systematic exclusion.
Not a piece of evidence that can be considered?
I believe it could be a piece of evidence that could be considered. And here I would point again to the fact that the trial court did engage in this discussion with counsel and invite proposed remedies from counsel just on the question itself of what was wrong with the source list. And below, trial counsel for all the defendants present weren't able to point to a single factor that was wrong with the source list, and they weren't able to point to any other source lists that they believed would be feasible to implement or that would actually result in a greater proportion or percentage of African Americans on Contra Costa County jury veneers. So to sum up, I believe certainly a trial court could consider that along with any other evidence that a defendant wished to present. Moving on to the prosecutorial misconduct issue. Here, I think it's very important to note, and it seems that appellant's counsel and I agree on the fact that the prosecutor's comments should be placed in context. I think where we disagree is about what that context means. I think here the prosecutor began her discussion of vengeance and retribution a couple pages, or perhaps 10 or so pages, I'm sorry, I can't remember exactly how many, before the challenge testimony. And that's when she first introduced the retribution and vengeance argument. And in doing so, this was first introduced in terms of a societal imposition of vengeance or retribution. And the prosecutor specifically linked this concept of retribution and vengeance to the idea that society should say enough is enough, and that's a decision that the jury should make in acting on behalf of the community. So I do think it's important to note that the prosecutor, when she first brought this up, there was no mention of the victim's family at all. Turning to the challenge testimony more specifically, even there the prosecutor placed this idea of vengeance and retribution in the context of societal or communal retribution and vengeance, and talked about it similarly to this court's holding in Zambrano, talked about it as being a proper form of punishment in lieu of the right of the individual's personal ability to exact personal retaliation. And I do think that that was a concept that this court reiterated in Zambrano that was important to remember when discussing societal vengeance in lieu of personal retaliation.
I would buy that if that's what the language actually says, but this is what it actually says. It says the victim's family are entitled to vengeance, plain and simple, from the state because they are not allowed to get it themselves. That would be called vigilantism, and that is not allowed. And the state owes the victim's family something in return, doesn't it? It owes them what they are not entitled to get on their own.
I agree that the prosecutor did reference the victim's family in that discussion, but I think in context of this larger discussion of retribution and vengeance, the prosecutor did posit this discussion as part of the societal sacrifice of personal retaliation. And I would point out that prior to the challenge testimony, the prosecutor said, we are not allowing the Jones family, again referring to the Jones family, but stating, or any family, or any victim's family to take personal vengeance on a defendant. So I think here what the prosecutor did is begin with the Jones family, but explain how the community as a whole could not take this type of personal retaliation.
I think the bothersome part of it, I mean, everything you say contextually may go to whether or not this particular statement was prejudicial or not. But as to the statement itself, what it is saying in its own terms is that the state is giving to the families the vengeance they are owed. I don't see how there's any other way to read this language, and that's just not permissible. I mean, that is buying into the notion that the state owes the families their private vengeance, which they cannot extract themselves, but the state is going to give it to them. That's what it says.
I agree, Your Honor, that I think without the additional language, we would have a much closer case. But
what is the additional language, just to be clear, that you think mitigates what Justice Liu just read?
I believe in the context that the prosecutor first introduced vengeance and retribution, and then in the earlier lines which preceded the challenge testimony, which talk about the Jones family or any victim's family to take personal vengeance on a defendant. I think the prosecutor began by talking about families and impliedly talking about this idea of community in general. And so I do think that while Justice Liu's concerns about the challenge testimony, I do understand those concerns. I think that if we're talking about this specific challenge testimony, it was introduced in this manner that was describing society as a whole.
So it has to be read in context, is your point, and we may or may not agree that there's enough context there to pull back from perhaps the implication that the testimony, or rather the words have on their own, but it sounds like you're conceding that on their own, those words are pretty troubling. That they might be a mistake on the part of the prosecutor were there not other language to put them in context.
Your Honor, I think in determining whether there's misconduct on the cold record, this court would have to ask if it's likely that the jury misunderstood those comments to mean that the prosecutor was arguing for vengeance or retribution, specifically, as Justice Liu said, to enact a private or to execute retribution for a private wrong. And again, I'm not conceding that there would be error here because of the context. And given the context, I don't believe a jury would have understood that language to mean that. And I do think we would have a different case. And again, I would need to know the complete facts in that hypothetical. I think we'd have a somewhat different and closer case.
Very different. I mean, it's a rather simple hypothetical. It's simply, there's no more context. I mean, there's no more context that has a bearing on this, right? This is the only mention of vengeance in families. And it sounds like in that situation, it seems to me, your argument suggests that it might be on the other side of the line, if we only had that language.
I'm sorry, Your Honor, yes. I believe based on that hypothetical in a vacuum where vengeance and retribution is brought up in this surprise manner without any other kind of context, I do believe there would be a much stronger case to state that the jury was being asked to impose retribution or vengeance to retaliate against a private wrong. I would point out again that here, or in addition, that here we also had an objection on the record in which defense counsel stated that there is no evidence that the victims wanted or the victims' families wanted this type of punishment, and the trial court sustained the objection. And I would also note that in concluding, the prosecutor here concluded her closing arguments talking about the community as well, stating that the jury speaks collectively for the community, and that the jury's verdict should be a statement that the community will not tolerate this. So I think we don't have a case where there is some sort of very emotional harping on the idea that the victim's family wanted the death penalty in this case. And just to respond to another one of the points that defense counsel made on this point, it's not the case that the victim impact evidence in this case was highly emotional or that it was even substantive. There were 4 victim impact witnesses that testified, and I believe their testimony, in closing argument, I believe the prosecutor devoted about a page to that testimony, did not discuss in any arguable way at all whether or not those individuals wanted the death penalty, but instead focused her comments solely on the fact that these individuals testified that they missed their daughter and they missed their granddaughter, and that it was a horrible experience for them to lose them in this way. And so I don't think it's true that there was some kind of emphasis on victim impact testimony in this case. And I think that also relates to the prejudice argument that we've been discussing here, that I think certainly if one is going to take the actual evidence in the record coupled with the objection that was sustained in front of the jury, there's simply no basis upon which to infer that the jury was likely to take the prosecutor's arguments to mean that the victim's family sought the death penalty. And seeing that there are no further questions, I would ask this court to affirm the verdicts. Thank you.
In response to the arguments in regard to the fair cross-section, that no court has found that the disparity in regard to the underrepresentation in Contra Costa County has risen to the level of warranting a reversal. The Buford case did find that. The Bell case did not find that, but the Bell case did not, as the prosecutor just stated, rest on an absolute disparity determination. In fact, the Bell case at length discussed the fact that the Supreme Court had not yet adopted, at the time of the decision, whether an absolute or comparative disparity test was the appropriate test, and it was not reaching the issue of whether or not 5% of an absolute disparity test was in fact violating the Constitution, but rather was deciding the case on the systematic third prong of the Duren test. And so it did not rule on 5% being an absolute disparity being constitutionally insignificant. And in fact, we cited in a letter brief to this court, in an almost identical population, the Supreme Court of Iowa just this year decided the issue of absolute and comparative disparity and spoke to why comparative disparity is much more applicable to a small population. I mean, if you assume that the people's position that absolute disparity should be considered as a determining factor, if you have a population of 10% or under and you don't have any representation from that community in the jury pool, you'd have an absolute disparity of 10%, but you'd actually have a comparative disparity of 100%. And so, I mean, how this played out for Mr. Enriquez, there wasn't a single African American on the panel that voted for him to die. And the panels that were summoned underrepresented the population in that county, and a comparative disparity test, which has now been adopted by the Ninth Circuit and been allowed for by the U.S. Supreme Court since Bell, the comparative disparity in this case was approximately 45%, and that was found by both the court in Curry and the court in Enriquez. Both those trial courts said that based on the evidence presented, we have approximately a 45% underrepresentation of the population that should be appearing for jury service. And so the comments of counsel, I don't believe are accurate in regard to how this court should make its analysis. And then finally, on the whether we concede that the use of Department of Motor Vehicles and voter registration lists are race neutral. We put on expert testimony that they were not, that they did not have a race neutral application. Hiroshi Fukurai, who testified from the University of California at Santa Cruz, wrote a book on this, on how those lists are underrepresented. And what I said in some of my initial comments were that the courts have been instructed to take notice of the underrepresentation in these two lists. And what is the reason for having a code of civil procedure that allows for other lists, which we suggested could be used, like utility lists, which are used in the state of New York, in order to get a more inclusive population in the jury pool? Why would we have that in a statute if there isn't a reason to use it? And
Mr. Bobrot, your time's expired.
thank you.
As all counsel is aware, this matter is not being submitted at this time and will be submitted or considered submitted at the time of appellant's filing of a supplemental reply brief as per the briefing order. I thank you all for your arguments. We stand in recess.
I will follow